any issue that the DIFC court should be competent into looking into this case. So the dispute was initially, the dispute was there before the agreement of DIFC laws applying was there. And I still believe Sultanate of Oman should have been, the court of Sultanate of Oman should have been competent into looking into this case rather than the DIFC. Because again, one node is not enough to give jurisdiction to DIFC courts.
So you tried to argue the doctrine of forum non-convenience. Am I correct? Are you applying that doctrine?
Really?
Are you applying the concept that this court is a forum non-convenience? Am I correct? Are you trying to suggest to us? Fair enough. All right. You can proceed. Sorry to interrupt.
I'm done. Thank you. I'm done.
Do you have further submissions? Please carry on.
Yes, I have another ground. My colleague is going to present now. Thank you.
Thank you.
Good morning.
Hello.
Morning.
May it please the court, counsel, my name is Ikra Islam, and I, with my learned junior Fazlullah Muhammad, will be representing the respondent, Ms. Raz Rani. With the permission of the court, the respondent is responding to the appeal of the Digital Economy Court by the appellant to disprove the appellant's claims and to prove that the court dismissed the claims on challenging the court's jurisdiction and presented a judgment on the right points of law. The respondent will respond to two grounds appealed by the appellant. First, the Digital Economy Court of the DIFC has jurisdiction over the claim of respondent under Article 5A, 1, subsection B, and subsection D of the Judicial Authority Law under Dubai Law number 12 of 2004. And the second ground, which will be addressed by my junior Fazlullah Muhammad, which states that the court correctly concluded that the appellant, a reasonable trader with knowledge of the circumstances surrounding the transaction, would have concluded the disputed trade was the result of an error sufficient to satisfy Article 37(1), subsection A of the DIFC contract law. Presenting the first ground of appeal, in the first instance of the court did not err in concluding that Clevity operated a distributed ledger with a node in the DIFC, which gives the DIFC court jurisdiction over the claim of Ms. Raz Rani against Mr. Payne under Article 5A 1B. Your Honors, would you like the respondent to present the facts of the case according to their interpretation of the events?
Is there a specific difference?
In the respondent's opinions, yes. Should I go ahead?
We'd like to hear only the differences, though.
Okay. So both parties trade on an online trading platform, as mentioned by the appellant. They trade in YAPL, but the respondent would like to note the point that the transactions on the databases still occurred, and as nodes process and witness every transaction, the node in the DIFC did the same. And also, the Clevity platform when automatically settled the disputed trade and made the relevant transfers of funds while the parties were asleep and unaware of the events on the platform. These are the differences between both the facts which were not mentioned by the appellant. Okay, I will be now moving to the first submission with the permission of the Your Honors. Is that okay?
Yeah, it's okay.
Okay. The first submission. The first instance, the court did not err in determining that the DIFC has jurisdiction over the respondent's claim, as the contract was concluded in the DIFC as concluded on Clevity's distributed ledger system. The node in the DIFC gives jurisdiction as a distributed ledger is defined as an asset database that can be shared across network of multiple sites, geographies, or institutes and nodes, as shown under the report by Government Office for Science called Distributed Ledger Technology Beyond Blockchain year 2016 on page number 5. This source can also
What is
be
the
seen.
report of?
Uh-huh.
What is
Can
the
you please
report
repeat? I'm
of?
sorry.
I mean, can you tell us which government?
Yeah,
Because
this report was under the Government Office for Science under the UK jurisdiction,
UK
and
government.
yes, and it shows the distributed ledger. It was called the Distributed Ledger Technology Beyond Blockchain, and it was year
Would it,
2016. You can also
is there
refer to
something
this.
within the DIFC itself that we could look at instead?
Uh,
Is there
under
any
the
further guidance within the DIFC that we could look at, or anywhere else in the Commonwealth?
this is just a definition. It's not really. It's an international definition, which is accepted by most of the jurisdictions. So that is the reason why we
So
have used this
when you say
specific.
it is accepted by most jurisdictions, can you give us more examples other than the report?
Yes. Yeah, if you really check, if you can go down on the sources itself on the respondent bundle, you can see that this specific definition is used by not only UK but other jurisdiction under international law. If you can go down on the bundle.
Okay, that's
Which
fine.
page?
It's yeah. If you can also on the index page, you can click on the source as well. If that's all right. Should I move on?
Shantanu, are you good?
Which page can you tell me?
Just a second.
In your bundle.
Yes, yes.
Legal method mode.
Yes, it's page number 33. And I've also highlighted the part which is on 34.
Okay. This UK government chief scientific advisor. This one you're saying, right?
Yes. Yes. Should I move on now?
Okay.
Okay, thank
Yeah.
you, Your Honors. Okay. Node on the network is meant as a processor of information for the network of nodes. Transactions are added to the database in blocks and is reviewed by the nodes. That's also referred as shown under the UK jurisdiction on paragraph 29, task for legal statement on crypto assets and smart contracts. And at the same source, which I've already mentioned previously, of distributed ledger technology on page number 60. Now I will be using the case of Zippo Manufacturer Co. against Zippo.com, where the court stated that it has personal jurisdiction over a website originating in a different territory if the website is accessible to internet users in the court's territory. Hence, Clevity's node in the DIFC is sufficient evidence for the DEC to conclude that the disputed trade contract was concluded in the DIFC because the node serves not just as a medium of information exchange, but also the location in the DIFC for finalization of the contracts. Moving on to proving this further with the second point, which is in regards to the interpretation of Article 5A(2) of the Judicial Authority Law, the court has determined the meaning and scope.
But has the appellant made this point?
Yes?
I'm saying,
Can you please repeat that? I apologize.
Has the appellant made this argument that you now seem to rebut or want to rebut?
Yes, the appellant has refused and ignored this point. So that is the reason why I'm addressing it.
So if they're not making this argument, we don't think there's any sense in you addressing us on it.
You don't want me to address on it? But because this
No,
is
I think
one of the main points which proves why the DIFC court has jurisdiction. That was the reason why the respondent brings
Okay, we'll hear
attention
you.
to
We'll hear
of
you.
the court.
We'll hear you.
Okay. The court has determined the meaning and scope of Article 5A of the law and Article 20 of the DIFC Law number 12, 2004. The law states that the DIFC Court of First Instance has original jurisdiction of the judicial authority law to hear the following civil or commercial claims and disputes arising out of or relating to a contract or promise contract, whether partly or wholly concluded, finalized or performed within the DIFC, or will be performed or is supposed to be performed with the DIFC pursuant to express or implied terms stipulated in the contract. To note specifically, Part 2 of the Article 5 states that DIFC has jurisdiction over the contract between claimant and respondent as a node in the DIFC does substitute the contract being concluded. This is shown in the case of Leadham against Oxford Investment, where the reasoning of Colin Judge was applied from the case of Khalil against Shua Capital, which is a DIFC court case. It stated that the jurisdiction of the DIFC court at first instance has original jurisdiction in line with Article 5A2 over commercial cases and disputes. The article gives a requirement that the transaction shall be related to DIFC activities, which simply means that such transaction should have been as a result of a particular commercial activity carried on the DIFC. This was established in the case of Al-Khurafi against Bank Sarsain, 2011. In regards to Part 5 of the DIFC Law number 10 of 2005, which is applicable for the interpretation of Article 5A1B, the test prescribed under Article 16.5 of the DIFC Law regarding the establishment of jurisdiction in commercial contracts must be applied, which states that if the parties do not specify the governing law of contract, the contract shall be governed by the law of the DIFC. In conclusion, the presence of the clevities node in the DIFC does substitute the first instance court's argument, the contract of the disputed trade being concluded in the DIFC. The respondent requests the court to dismiss appellant's appeals on the reasoning presented by the respondent. Thank you.
Okay. Rishabh, you're there?
If there are any further questions, I can address that.
Rishabh, you're there? Just give us a second.
Hello. Sorry. No, what's wrong? Is this the appellant?
No, I have finished mine, the respondent, the senior respondent. If you have any further questions, you can ask.
No, actually, you came out of turn. We wanted to hear the appellant, but you began without both of their speakers speaking. Anyway, we'll hear the appellant.
No, actually, according to the rules we have been given, first the senior appellant goes, then the senior respondent goes, then the appellant, the senior appellant's rebuttal goes. That's the rules we have been given.
Okay, cool. So who will be hearing now?
The senior appellant rebutting.
The senior appellant.
Yes.
Okay. Can we hear you, please?
Yes, so that would be me again.
Okay. So, Ms. Alia, would you like to continue?
Hello.
Yes, sorry, we can't hear you, Miss Alia.
Hello?
Yes.
Yes,
Continue.
can you hear me? Yes, okay. So, Your Honor, I would like to introduce a case in common law, which is called Enretizos versus Enretizos Securities Litigation. It is a case that was the first to consider the location of a note when giving jurisdiction or appointing jurisdiction to a specific court. This case, Your Honor, did give jurisdiction based on the majority of nodes placed in a certain location. It did not give jurisdiction based on the minority of nodes. In our case, the one node out of hundreds of nodes is not even the majority. It doesn't even cover half of the nodes scattered across the different countries in the world. So, being said by the respondent that the IFC courts are competent to look into this case because of the location of a node or because of the location of the respondent residing in Dubai, I would believe that the respondent being a resident of Dubai, not within the DIFC, and one node being placed in DIFC is not sufficient to give jurisdiction. If we would look back at the previous precedent, which I mentioned a while ago, they considered the majority of nodes placed in a certain location to give jurisdiction or to appoint jurisdiction. It wasn't by one node or two nodes, it was by the majority. So therefore, I would request your honorable court to reverse the decision of the first instance court regarding jurisdiction given to the DIFC.
The reference to this judgment is in which page?
In Retizo's litigation in the court bundle, it would be at the end of the court bundle. We have attached the first page of every.
This is Tezos Securities. That's what you're
Yeah.
referring to.
Yes.
Okay.
Thank you.
Thank you. Rishabh, you have any questions? Rishabh?
Yeah, Shantanu.
Any other questions?
No, nothing from me.
Okay. Thank you. Thank you, Miss Alia.
Thank you.
So, who is next?
May it please the court, first of all, can you all hear me?
Yeah, we can.
All
Yes,
right,
sure.
I, Shama Salhi, appear on behalf of the appellant, and I will begin with my second submission. This court should find in favor of my client for the following reasons. Firstly, there is no relevant mistake, Your Honor, and secondly, that the mistake did not occur on the term of the trade. With respect to the first point, Your Honor, it is unrealistic to expect that programmers have foresight, and errors can occur in a variety of ways. Therefore, Your Honor, it may not have been possible for my client to have, at the time of the trade, to have known or ought to have known that this incident would have occurred. And this is what will be explained. Throughout what is evidenced in the conditions that are illustrated, Your Honor, in Article 37, 1A, the DIFC contract law, which states that a party may only avoid a contract for mistake if, when the contract was concluded, the mistake of such importance that a reasonable person in the same situation as the party would not have concluded at all if the true state of affairs had been known, and the other party made the same mistake and it was contrary or was also mistaken or caused the mistake or knew or ought to have known of the mistake, and it was contrary to reasonable commercial standards of fair dealings to leave the mistaken party in error. This article, Your Honor, sheds the light on two main points that will have to be presented for my client to have potentially caused the mistake. Firstly, the state of mind as to whether he knew or ought to have known of the mistake. Secondly, whether it was contrary to reasonable commercial standards of fair dealings to leave the mistaken party in error. As a case in point, Your Honor, in the precedent, Coin PTE Ltd versus B2C2 Ltd, it provides that even to prove that my client has intended to cause the mistake or even ought to have caused the mistake, he would have to analyze at what time the programmer was, which is impossible to assess the state of mind of the programmer. It is just unrealistic, Your Honor, for Mr. Payne to have willingly intended or caused a mistake or even have predicted of all possible outcomes of the transaction between Beta's algorithm or even any other programmers. In addition, Your Honor, in this case, it is not contrary to reasonable commercial standards of fair dealings to leave the mistaken party in error. According to the common practice of law and offer and demand, Your Honor, setting an inflated price which results of a law offering on the platform is in fact illegal. Let me shed the light on why that is. As stated, it aligns with the law of offer and demand. This means that prices will automatically increase if the demand exceeds. Nevertheless, Ms. Rani had entered into the trade under mistaken beliefs that the rates at which they were entering into the trade represented and did not deviate from the true market value was not a mistake as to the terms of the trading contract, but instead, Your Honor, was a mistaken assumption as to the circumstances under which the trading contract would be concluded. Furthermore, Your Honor, let's assume that the mistake does in fact exist. Article 37(2)(b) tackles and states that, however, a party may not avoid the contract if the mistake relates to a matter in regard to which the risk of mistake was assumed, or having regard to the circumstances should be borne by the mistaken party. So perhaps there is a mistake, and it was assumed based on the circumstances, Your Honor. When entering into a platform, the consent is given to the algorithm to perform any autonomous activity, Your Honor, without any human activity. Hence, why Ms. Rani has accepted that any risk could occur, which in fact has occurred in this case. And so on that basis, Your Honor, I would like to conclude that the court is invited to give immediate judgment on the claim that there is no relevant mistake, because the state of mind of the programmer could not have caused or even ought to have known of the probable mistake, and that the mistake did not occur on the term of the trade. Unless Your Honor has any further questions of any of my submissions.
Rishabh, are you good?
Yep, I am. I was wondering if there was any further submission.
Okay, thank you. So we move on to the next, I think, respondent.
Thank you.
Good morning, everyone. Am I audible?
Yes. Yes, you are.
May it please the court, as introduced by my learned senior, I'm Fazlullah Muhammad, appearing as junior counsel for the respondent in this appeal, Ms. Raz Rani. Your Honors, I will address the second ground of appeal and attempt to convince this court to uphold the decision of the learned judge in the court of first instance, which was based on sound legal reasoning, and conclude that the disputed trade can be voided for unilateral mistake by showing that the appellant had constructive knowledge of the respondent's mistake as opposed to actual knowledge. I shall be making one submission which will elaborate based on statute and case law as to why the decision of the court of first instance must be upheld. With the court's permission, I shall now begin my submission.
Sure.
Your Honors, the court of first instance did not err in concluding that for the purpose of a claim to avoid the disputed trade for unilateral mistake under Article 37, 1A of the DIFC contract law, it was sufficient for the respondent as a reasonable trader with knowledge of the circumstances surrounding the disputed trade would have concluded that it was a result of a mistake. In other words, it would be sufficient to show that the appellant, as a reasonable trader, had constructive knowledge of the mistake as opposed to actual knowledge. Article 37(1)(a) of the DIFC contract law provides that a party may only avoid a contract for mistake if, when the contract was concluded, the mistake was of such importance that a reasonable person in the same situation as the party would not have concluded it at all if the true states of affairs had been known, and A, the other party, that is, the respondent, made the other party, that is, the appellant, made the same mistake, or was also mistaken, or caused the mistake, or most importantly, or knew or ought to have known of the mistake, and it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error. This means that the disputed trade can be avoided if the appellant ought to have known of the significant unilateral mistake on the respondent's part. In other words, the disputed trade can be avoided if the appellant had constructive knowledge of the mistake. If your honors would kindly turn over to the highlighted portion on page 22 of the respondent's bundle. May I proceed?
Yeah, page 22. Yeah.
It can be seen that this provision of the DIFC contract law is based upon Article 3.51a of the UNIDROIT Principles of International Commercial Contracts 2004, which consists of the same language as the DIFC contract law. The relevant elaborative commentary, which is the first highlighted portion on page 24 of the bundle, clarifies that for a contract to be voidable due to unilateral mistake, the non-mistaken party must satisfy any of the four conditions found in Article 3.51a, which is the equivalent of Article 37(1)a of the DIFC contract law. For the purpose of this appeal, the relevant condition is the third. That is, the non-mistaken party ought to have had constructive knowledge of the mistake, following which it would be unreasonable and unfair to leave the mistaken party in an erroneous state. If your honors would kindly look at the second highlighted portion on page 24 of the respondent's bundle, it can be seen that the commentary further provides that the test for constructive knowledge is that the appellant's constructive knowledge should be the same as what a reasonable person should have known if they were in the same position as the appellant. Your honors, any reasonable trader who regularly undertook algorithmic trades on the Clevity platform, like the appellant, should have known and would have developed the awareness that the sale of Yapple at 250 times higher than the market price was an abnormal situation that could only be caused by an unforeseen error, malfunction, or interference, and insisting upon such a sale would put the mistaken party in an unfair position.
Okay.
Your honors,
My
supplementing the
question is, sorry,
aforementioned.
sorry, sorry.
Sorry. Yes. Yes, Your
You
Honor.
represent a party. You represent who exactly in terms of the parties?
I represent the respondent, Ms. Razrani.
No, in the transaction, what was your role in the disputed
Uh,
transaction?
Ms. Razrani was the trader who undertook algorithmic trading on the Clevity platform through the Alpha algorithm, which under which Mr. Payne sold 100 YPE, that is Yapple, to Ms. Razrani at 250 times greater than the prevailing market price. So Ms. Razrani's account was debited for a highly inflated rate of USD 250,000.
Okay. Were you aware that you would be charged 250,000 when you entered into the transaction?
No, Your Honor, because the transaction had taken place through a deterministic algorithms while the parties were asleep. There was no actual knowledge.
Okay.
May I proceed? Your Honors, may I proceed?
Yes. Yes.
Your Honor, supplementing the aforementioned point, applying Lord Mance's view in Coin Pte Ltd and B2C2 Ltd, which can be found in the highlighted portion on page 40 of the bundle.
Yes, proceed.
The disputed trade should have been reversed as soon as the appellant, as a reasonable trader, identified that the transaction was caused by an obvious malfunction. Moreover, looking at the highlighted portion on page 38 of the bundle, Lord Mance also aptly stated that a computer malfunction should not be given the status of a dominating force that forces contracting parties to abide by a highly unusual and unfair trading situation arising out of the said malfunction, a situation which runs contrary to the reasonable commercial standards of fair dealing, which stands against the point of my learned opposing counsel, who claims that it is not contrary to the standards of fair dealing. Your Honors, consequently, as stated in Article 37(1)(a) of the DIFC contract law, it would be contrary to the principles of fair dealing to leave the respondent in a highly disadvantaged position caused by a mistake which the appellant ought to have had constructive knowledge of. Having established that the DIFC contract law only requires establishing constructive knowledge on part of the non-mistaken party in a unilateral mistake claim, the next logical step would be exploring the common law stance in this regard. I now refer to the British Columbian Supreme Court case of
Sorry, I
Craig
had
Estate.
two questions
Sorry.
before you go there.
Yes.
Uh, is the platform represented before us?
Sorry, I couldn't get your question.
No, is the platform before us? The Clevity platform. Is someone representing them?
No, Your Honor, there's no representative of the Clevity
You are
platform.
effectively the buyer and the appellant is the seller. Am I correct?
Yes.
And you stated earlier that this entire transaction took place when both parties were asleep. Am I correct? Or
Yes.
should have been asleep.
Yes.
So neither party actually could or would have done anything, uh, let's say, with knowledge because they were both sleeping.
Yes.
But you just now argue, and that's what I understood from your argument, is that there was some sort of constructive knowledge or knowledge that is attributable to the appellant. Am I correct?
Yes, Your Honor. What I have argued until this point is that the law is clear on the fact that constructive knowledge is sufficient for establishing a unilateral mistake claim. What I will be addressing in my further submissions is how that constructive knowledge is to be inferred. So that will clarify, hopefully, your questions as to
Okay.
how we are assuming constructive knowledge on part of the appellant.
Okay. Let's hear you. Sorry.
Okay. Your Honors, I now refer to the British Columbian Supreme Court case of Craig Estate and Higgins, which is found on page 14 of the bundle. 1414, please. Would Your Honors like a brief overview of this case?
Yeah, go on. Go ahead.
Yes. In this case, the court had to consider if an offer to settle entered into by the plaintiff's solicitor under mistaken terms was voidable for unilateral mistake, and whether the defendant or his solicitor ought to have had constructive knowledge of the mistake. This is similar to the facts of our case in the sense that the respondent's algorithm, alpha, had entered into a faulty transaction on mistaken terms on behalf of the respondent. In this case, it was held that in a case of unilateral mistake, it would be unfair to allow a non-mistaken party to enforce the contract if it possessed constructive knowledge of the mistake. This decision, along with Lord Mance's reasoning in Quine, is in line with Article 37(1)(a) of the DIFC contract law, which states that constructive knowledge is sufficient. Your Honors, having established the aforementioned, I shall now address how constructive knowledge is to be inferred in a situation of unilateral mistake. I now refer to the Canadian High Court case of McMaster University against Wilshire Construction, which is found on page 12 of the bundle. Would your honors like a brief overview?
Yeah.
In this case, the defendant had mistakenly omitted a part of the construction tender which contained a significantly important clause. The court had to consider whether the plaintiff, as a reasonable person, ought to have known of the defendant's mistake and how such constructive knowledge can be inferred on part of the non-mistaken party. So this is similar to our case where, contrary to the contention of my learned opposing counsel, the unilateral mistake is one that is fundamental and goes to the terms of the contract and which has significant consequences on the future of the transaction because a sum of 250,000 US dollars is in question, and it is fundamental as it goes towards the consideration given in the contract. So in this case, it was held, applying the locus classicus of Hartog and Collins against Shields, that constructive knowledge on part of the non-mistaken party can be inferred if the mistake would also be obvious to a reasonable person in view of the surrounding circumstances. Your honors, the aforementioned decision can be adopted to the modern emergence of automated contracts. It is undeniable that the disputed trade took place via algorithms without human interference, thus preventing any possibility of actual knowledge on part of the appellant. However, based on McMaster, constructive knowledge can be inferred on the basis that if the appellant was hypothetically aware of the circumstances surrounding the disputed trade, it would have been obvious to him, as a reasonable trader who regularly undertook trading on the Clevity platform, that a mistake had occurred and the contract could not be reasonably concluded on the mistaken terms. This can be supplemented with Lord Mann's reasoning in Coin, found in highlighted portions on page 39 of the bundle. Lord Mann's termed the test for constructive knowledge as, and I quote in verbatim, a test which relates what actually occurred to natural human reactions given knowledge of what occurred. It matters not whether one assumes such knowledge at the time of the transaction or prophetically in advance. So this addresses the learned opposing counsel's contention that the programmer did not have advanced knowledge of the mistake occurring. So according to the Lord Mans, the answer is the same. If it would have at once been perceived that fundamental error had occurred, relief should be available. So Lord Mans's point in this reasoning is that as soon as a mistake comes to the attention of the parties, they should not undertake unconscionable or unethical behavior and snap up at a mistake and try to enforce it to their benefit, which would be against the principles of fair dealing. In this case, this would mean that it is irrelevant whether the appellant had actual knowledge of the algorithmic errors when the disputed trade took place. What matters is that when the matter came to the appellant's attention, he ought to have realized as a reasonable trader that only a fundamental mistake could have caused the highly abnormal transaction which concluded the sale of Yapple at 250 times greater than the prevailing market price. This defeats the appellant's contention that he could not have known about the mistake as it took place through deterministic algorithms. In the Singaporean High Court's decision in Ho Seng Lee Construction and Nian Chuan Construction, which can be found in the highlighted portion on page 18 of the bundle, can be used as reiterative authority for the above-mentioned test. It stipulated that the test for constructive knowledge must be analyzed in terms of what a reasonable person ought to have known in similar circumstances. This means that the appellant's actual knowledge is irrelevant. What is relevant that objectively any reasonable trader undertaking regular transactions on the Clevity platform like the appellant ought to have known that an unusual transaction was the result of a mistake or a significant error. And thus the respondent would be well within their rights to have the contract declared void for unilateral mistake. Your honors, in conclusion, the respondent adheres to the view that the Court of Instance did not err in dismissing the appellant's claim by relying upon Lord Mans's reasoning in Coin. DIFC law statutorily accommodates the notion of a mistaken party's constructive knowledge within the doctrine of unilateral mistake. For the purpose of Article 37(1)(a), it is sufficient that the appellant ought to reasonably have known that the disputed trade was the result of a mistake. Furthermore, the objective reasonable person test in established case law allows for the imputation of the appellant's constructive knowledge, and thus the respondent appeals to this court that the contention of the appellant be dismissed. Thank you. If there is any further questions, Your Honors, I'll be
No.
prepared to address them.
No,
Do
no.
we hear the appellant's rebuttal?
Thank you.
Hello, yes. To rebuttal, Your Honors, the claims made by the opposing side are unreasonable to my client. This is because both parties have consented to give autonomous trading, meaning that even if the respondent was awake, as argued by the junior respondent, the disputed trade was going to occur either way, without any human or physical activity. And regardless of their knowledge, Your Honor, autonomous trading had to occur anyway. That's it. No further rebuttals, Your Honor.
Okay.
All right, thank you. Shantanu, do you want to move to a breakout or how does this work?
Yeah, just
How do we do
uh,
that?
we have time, I think another 30, 35 minutes. Other part, I think. You can break out for 5 minutes?
Sure. Okay, 1 minute. How do we go to the breakout from the main chat?
So we have to leave from here and then join the judges room.
Lead from here, right? Yeah, okay. I'll see you in the breakout. Oh, Shantanu, wait, just go on mute. I'll call you.
Okay, better.
Easier, much easier.
Yeah.
Hi. Sorry, we're back.
Hi everyone.
We've had our discussions. Could we have all the participants like together, maybe? Can we see everyone, or am I having internet issues?
No,
Can
I
you
can
see
see.
me?
No,
Am I visible?
I can't see anything. It's a black screen for me. Anyway, nothing major. Okay, guys. So I think we had two comments. We've already made a decision. I think we'll email it to the admin. But at least Shantanu and I both agree on one thing. If you are, quoting law, you always must introduce what the case is, what is the court that handed it down, what were some of the facts, and how are those facts really relevant. If you just, and if you're relying on a particular case with verbatim quotes, you must drive home the point as to how that case is relevant. We will not necessarily have the full time to read all of it instantly. So maybe try that. Uh, that's one.
Yeah,
And
I apologize. I cannot hear you at all. Like I cannot understand the point. I'm so sorry.
all right. Sorry, is it bad network or am I too soft?
It's the background noise is very like loud. That's the
Uh,
issue.
Give me a minute. Is this better?
Yes, yes.
Awesome. Okay. So I was just saying that, see, there are two bits of advice into each party, and maybe it will help your next round. One is if you are making, a rebuttal, and this is not really critical of anything else. So if you are, say, doing a rebuttal, do pick up a point from what the other side says and rebut it specifically. And that applies to both the, appellant and the respondent, because the appellant gets a chance at rebuttal, but the respondent is supposed to do that when it opens. So you must say, my learned friend argues A and B. I respond to A and B in this order. Uh, that's how we'd be interested in really hearing it. You may otherwise, make an argument and respond to something that was never argued. Um, Very unhelpful as far as practice is concerned, because the court really doesn't want to hear some a response to something that was never argued. Um, Secondly, is what I was saying is in terms of case law, when you're citing something and you say this is relevant, you really need to, especially if you seem to want to quote it heavily, you really need to make reference to the facts of that case and how they're similar to yours. You'll have to drive home the point saying this is the case, this is, in similar circumstances, this was held, and this is why we believe that you should follow it as precedent, because most of this is just persuasive, but you must drive home how the facts or the law is very similar. And use lesser cases if you have to, but if you're making the argument, be very specific with how exactly does that apply to your facts. I think that's it from me. Shantanu?
yeah, that's the same point which we discussed. So, like, if somebody is arguing on law points also, so if any rebuttal is to be done, then specifically, if any particular point has to be rebutted, that particular point has to be referred to. And that's it. Nothing more from our side. We'll update in the DIFC and scoring sheet. We have to do it in the next 15 minutes. So good luck.
Yeah, good luck, guys. Just to think that I think it was a close one. So, I think you guys were both very good. So both teams were good. So give yourselves a pat on the back. Thank you.
Thank you so much.
Thank
Pleasure
you.
meeting. Thank you.